Welcome to the top 10 things to know regarding procedural safeguards for parents' rights and special education. As a parent, the Individuals with Disabilities Act, or IDEA, provides you, acting on behalf of your child, some protections. These are called procedural safeguards. Number 1. You should receive a copy of the procedural safeguards for your child with a disability one time a year. It should fully inform you about the safeguards under IDEA. You must be permitted to inspect and review any education records regarding your child that are collected or maintained or used by the educational agency. Number 2. Before a school can begin evaluating, they must first get your consent. Consent means you have been fully informed in your native language or other mode of communication. Understand and agree in writing to that action. Understand that it is voluntary and you may withdraw your consent at any time. You do have the right to refuse consent based on the procedural safeguards. Number 3. As a parent of a child with a disability, you must be afforded an opportunity to participate in meetings regarding identification, evaluation, educational placement, and provision of a free, appropriate public education to your child. This meeting should be scheduled at a mutually agreeable time and place and communicated appropriately. Number 4. An independent educational evaluation, IEE, is an evaluation of your child that is conducted by a qualified examiner who is not employed by the district or AEA. It is your right to request an IEE, especially if you disagree with an evaluation. A parent is only entitled to one IEE at public expense each time an evaluative disagreement. Number 5. Mediation must be made available to you to allow you and the public agencies to resolve disagreements involving any matter under IDEA. You can ask for mediation with or without filing a due process complaint and or before or after filing a complaint. The process must be voluntary and conducted by a qualified and impartial mediator. Number 6. Parents have the right to file a due process complaint which involves going to court. The Department of Education arranges for the hearing. A person with the title of administrative law judge listens to the evidence at a due process hearing and makes a decision. The DE must keep a list of ALJs, including qualifications. Number 7. In any action or proceeding brought under IDEA, the court, in its discretion, may award reasonable attorney fees as part of the costs to the prevailing party. Number 8. The age of majority is 18 in Iowa. All minors attain their majority through marriage or when tried, convicted, and sentenced as an adult, unless deemed incompetent under Iowa law. 1 year prior to the age of majority, the child will be informed of the transfer of rights when they reach the age. Number 9. Students may be removed from an educational setting such that they would do the same for a child without disabilities. If removed for more than 10 school days, the student must continue to receive educational services and progress toward IEP goals, receive behavioral assessment and intervention and modifications. Number 10. Parents at times will group and unify with advocacy groups such as Disability Rights Wisconsin. Recently, Racine Unified School District was ordered to contract with an independent consultant to conduct a full district-wide review of its special ed programming. Some advocacy groups will provide you with a template to request an IEE.